Hello everyone. Our today's topic is contempt of court. So we will discuss about contempt of court today. Any conduct that brings the authority and administration of law to disrespect is known as contempt of court. In Constitution of India, Article 129 and Article 215 empower the Supreme Court and the High Courts to punish people for their corresponding contempt. Apart from these, there is separate Contempt of Court Act 1971 has also present in our judicial system, in which section 2A of the act 1971 defines what are the types of contempt. In section 2A of act 1971, contempts are two types, that is civil contempt and criminal contempt. According to section 2B of the act, civil contempt is any willful disobedience to any order, judgment, decree, direction, or writ or any undertaking given to the court is considered as civil contempt. So, the essentials of civil contempts are there must be a willful disobedience and the disobedience of the order, judgment, decree, or any other related to order of the court. It must be valid. If it is not a valid order, judgment, decree, then it won't be considered civil contempt. And the another is section 2C, which defines criminal contempt. Criminal contempt is publication of any matter, whether by words, spoken, signs, or visible representation, or in any other manner which is tending to scandalize or tends to scandalize the authority of the court, or which interfere or tends to interfere in the administration of the justice, which obstruct or tends to obstruct the administration of justice, which interfere or tends to interfere in the due course of the judicial proceedings, is considered criminal contempt. So, there are two types of criminal contempt, civil contempt and criminal contempt. Now, we will discuss what are the defenses if any contempt has been imposed on any person. So, in civil cases, like if civil contempt has been imposed on any person, then he can take defense of certain points, like disobedience was not willful. If the disobedience is not willful, then he won't be punished. Number second, order may have more than one reasonable interpretation. Like if any order has been passed by any judiciary, any judicial authority, and that order has more than one reasonable interpretation, then in that situation, contemner can be exempted from contempt of court. Number third is no knowledge of the order. If the person is having no knowledge of the order has been passed by the competent authority, and he was unaware about that order, then it would be a ground for defense in cases of criminal contempt. Number fourth would be compliance of the order is impossible. If any order, judgment, decree, or writ has been passed by any competent court and that is impossible to comply, then it would be considered as a defense in the cases of civil contempt court. Number fifth would be lack of jurisdiction on the part of the court which passed the orders. That means if any order, judgment, decree, writ has been passed by any court which has no proper jurisdiction, which has no actual jurisdiction, in that case, the contemner can take plea of defense that he is not held guilty in civil contempt. Now we are going to discuss what are the defenses available in criminal contempt? As we have already discussed that criminal contempt has been defined in section 2C of the Contempt of Court Act 1971, which means any publication which tends to scandalize the authority of the court, or which interfere in the due judicial proceedings, or which obstruct the administration of justice, would be considered as criminal contempt. Now we are going to discuss what are the defenses available in criminal contempt. So, in Criminal Contempt Act 1971 itself, defenses have been given. Number first defense has been given in section 3. That means innocent publication and distribution of matter not contempt. Like if any matter is publicized which is innocent and distributed, but the reason here is that that is the innocent publication, then the person will not be held liable under the Criminal Contempt Code Act. Number second defense is fair and accurate report of judicial proceedings, not contempts. Number of times cases have been registered for reporting judicial proceedings, but the person who has been caught under this act according to this provision, then he can get defense on the basis of section 4 of the act, that the publication or the report of the judicial proceeding was fair and accurate. There was no additional intention and malintention was included in that reporting. Number section 5, the next defense is fair criticism of judicial act is not contempt. If anyone or any group of person is held liable for criminal contempt, then he must have to prove that the fair criticism of judicial act has been done by them, that is not punishable by the judiciary under this defense. The next ground is section 6, complaint against presiding officer of subordinate court to a higher court in good faith is not a criminal contempt. The next ground for defense has been mentioned in section 13, no punishment for contempt unless the court is satisfied that contempt is of substantial nature and it substantially interfere with the due course of justice. Like if the competent court is believes that there is no substantiality in the contempt of court, then they can dismiss that plea of contempt of court. These are the 5 grounds of defense in cases of criminal contempt. Thank you and keep watching my videos.